In less than 24 hours, the Trump administration has gone from potentially being held in contempt of court for not following a judge's orders regarding the return of deported Venezuelan migrants to being told by the Supreme Court that it could continue to deport migrants under the Wartime Alien Enemies Act. Now, while the administration is claiming victory, the highest court did add that detainees must be afforded due process and given time to challenge their detentions before they're taken out of the country. That was not afforded to the 200-plus migrants on the initial flights last month to the notorious El Salvador prison, where they remain tonight, folks. Rejoining me now is MSNBC legal analyst and former acting assistant attorney general for national security, Mary McCord. Mary, I want to start out of the gate with a sound from the White House press secretary, Karoline Leavitt, being asked about the Supreme Court ruling regarding deportees. Just take a listen.
With regards to the Supreme Court ruling on the Alien Enemies Act, you're right. It was a win for the administration, but the justices also said that deportees are entitled to due process. Does the administration agree with that?
That's not quite true, Gabe. They said that they are entitled to a habeas petition, and we are going to continue to comply with the law, and we are wholly confident that every single person that has been deported under the Alien Enemies Act, every person that will continue to be deported under the Alien Enemies Act qualifies for that deportation.
So, Mary, I was not a criminal lawyer, corporate lawyer, so I look at this a little bit differently, and I'll admit, but at least my reading of the Constitution, my understanding of the law, is that habeas corpus, we have the body, means the state now has got legal possession of you, still requires due process. So, Caroline, if you're watching, Caroline,
Not sure where she got her law degree, but I think she's misinterpreting the Supreme Court. And there's a number of things here. All 9 justices agreed that the deportees are entitled to habeas corpus, meaning a procedure to have notice that they're being deported under the Alien Enemies Act and have the opportunity to challenge that. Not just to challenge whether they're members of Tren de Aragua, they certainly have that right, but also to challenge the use of the Alien Enemies Act in this way as a basis for deporting members of this alleged gang. The other thing I would say is this still does not absolve the administration from potential contempt, right? Mm-hmm. Because even though the Supreme Court has now said they have not ruled on the applicability of the Alien Enemies Act, they've only said the proper forum is habeas corpus, not an Administrative Procedure Act claim in front of Judge Boasberg, because that was that claim and under the Administrative Procedures Act. It's like this is the wrong cause of action in the wrong place. So you've got to use habeas. You've got to do it in the jurisdiction where you're detained. And so I'll come to that. So those who haven't been deported yet, many of them are in Texas. They could be in other places. They have a right. But that does not absolve the administration from violating, if it did violate, Judge Boasberg's orders on March 15th, because the courts have been clear, including the Supreme Court, even if ultimately a judge's order is overruled, you don't get to violate it when you disagree with it. You have to appeal it. So he can still keep up these hearings to determine, what he's going to do if and when he determines they were in contempt. And the other point I would make is that even though some 140 or so people were already deported to the El Salvadoran Terrorist Detention Center, they still would now have rights to seek habeas, and they're no longer in Texas. And my understanding is, by law, those habeas, when you are outside the country, can be brought in D.C. So they may find themselves back in the federal court in D.C.
What's happening with these folks? Is there anybody representing them at all? Folks, what we've witnessed is our government rounded up these 200-plus people, did not process them the right way at all. So they have no idea who they got. All they know is they're Venezuelan, they have Hispanic.
Tattoos.
Yeah, right. Hispanic surnames, and that was enough. Mm-hmm. So who's now advocating through the judicial process to get habeas for them, to get due process for them, because this seems to be, they seem to be forgotten in all of this right now.
And I think that's one of the major problems with habeas as a remedy. And to be clear, I don't think the court was right about habeas as the only remedy, and neither do the 4 dissenters. Or at least they think it's a hard question whether habeas is the right remedy versus the Administrative Procedure Act, and they shouldn't have taken it on this emergency docket, right? And that's what the 4 dissenters say as well. But even if habeas is the right way, it's so difficult. I'm not sure anybody knows. The government hasn't disclosed exactly who was on those planes under the Authority of Alien Enemies Act. It's one of the things Judge Boasberg's been trying to get to the bottom of. You know, who were those people? Where's the list? I'm sure families maybe have started to figure out, and then they've got to find a lawyer who's willing to file the habeas petition, et cetera. There can be class action habeas, so maybe that's something that can take place, but I can guarantee that the immigration lawyers who work on these kind of matters have probably been scrambling ever since this opinion came out last night.
Trying to figure out how to get them in front. I got one more.